1996, we merged, and we entered into a contract with the city to take over all of the function of the Municipal Legal Aid Bureau, and the city agreed to finance us in various ways. One was to provide housing for our program in the old City Hall Annex. They gave us lots of space, all free. They paid for our phone service, which they continue to do to the present day. And if you look in the ordinances of the city, you'll see that the ordinances relating to the Legal Aid Bureau are suspended pending the continued performance of this contract that the city has with New Haven Legal Assistance. Now, when I said earlier that our roots go back to 1927, having incorporated the Legal Aid Bureau into New Haven Legal Assistance, that bureau was started in 1927. And we are now that bureau as well as New Haven Legal Assistance, all now New Haven Legal Assistance. That was a bureau that provided civil legal services to people, poor people in New Haven, run by a part-time attorney, and as I said, with a large number of Yale law students, generally 50 or so per semester, who would go down there and work several hours a week, and did fantastic work, and had a manual that they created that was used on a regular basis to do all kinds of things. They handled eviction cases, paternity cases, bastardy cases as they were called then, bankruptcies, wage attachments, bank executions, and we got them by the dozens. We would have hundreds of cases, really, 200, 250 cases a month coming in there. All we did was give advice. We had forms that people could use. We helped people deal with problems that they had. But a part-time attorney wasn't enough to really be able to handle the problem. When I started then, I was full-time because Ford paid the other part of my salary to make me be able to take on that job. And we started for the first time litigating. And as I said, I was brand new. I really learned on the job. I consulted with people who are on our advisory council, Charlie Parker being one of them, Joe DeSessa being one of them, on a regular basis to figure out how to proceed and what to do. It's interesting, when we started representing people in eviction cases, that was something new. They had not been represented when they were being evicted. And what I did was I simply took the position that all of the defenses and all of the pleadings that were available in regular civil litigation should all apply to summary process, which is eviction litigation. And that's what we did. We simply incorporated and transposed everything over, and generally it worked. Although some judges would not allow discovery, for example, in eviction cases. That was prohibited because, as one judge said in an opinion, these are not civil actions. Now, what they were, if they're not civil actions, I don't know. But that was the language of the discovery rule. In all civil actions, you're entitled to this, and the way to get around that was to say, well, these are not civil actions. This is a special statutory proceeding. Not a civil action, and you don't get it. That thinking has long been abandoned, and discovery is now readily available. But it used to be something that was talked about, that we were filing pleadings in eviction cases, and this was sort of unheard of. It was a novelty that this would happen. And when legal assistance first started up, a committee was appointed to examine all of our eviction files in the court, to look at the pleadings to see whether they could find anything that we were doing that was inappropriate, unethical, illegal, whatever. And they had about 4 attorneys who were looking at these things, looking to see whatever they could find. And the report of the committee came back saying, we can find nothing wrong. One person came back and said, this stuff is pretty good. But the goal was to see if they could find anything wrong, and they could find nothing wrong. That was the report. When legal assistance started up then, having been incorporated in September of '64, a certain group, and a fairly substantial group in the private bar, were vehemently opposed to legal aid, to expanding legal aid. The argument was, we have a legal aid bureau, now we have a full-time person there, that's enough, that's all we need. Why do we need any more? This is a big expansion right there. There isn't the need. You haven't demonstrated the need for any additional legal services. We don't need it. There was also the concern that what we were doing was illegal or unethical. We were soliciting clients, we were advertising, we were going out and saying, we're here, we will represent you, and we will be able to assist you. There was a feeling that that was unethical. There was a concern by members of the private bar that we would be taking business away. We would be representing people who otherwise would go to a private attorney. And the example generally given was, if you were to take a divorce case for somebody who was being divorced and they needed to be represented, that case would probably have been handled by the private bar, because that person, one way or another, would come up with the money. They would get it somehow. And the example was, if a woman is being divorced, she has a boyfriend, and he'll pay the money to represent her in the divorce and that kind of thing. So there was this big fear that we would be taking cases away from the private bar, fee-generating cases or fee-paying clients, and that they would lose business. There was a fear that we might change the standard of practice. I mean, look at summary process. Nobody was, landlord attorneys would go in and get judgments. Nobody would appear, nobody would plead. So now there was going to be a new kind of practice going on if we were going to be involved in cases where nobody had been involved before. So there were meetings of the local county bar association, the most highly attended meetings that they had ever had. They stopped serving roast beef because it was too expensive. Because too many people were showing up for these wonderful roast beef sandwiches that they would have. But it used to be 15 people maybe would show at a meeting. Now we were having 50, 60, 70 people showing up at these meetings. So they couldn't feed them. But the people were there, and the attacks on New Haven legal assistance were really vehement. We were outlanders. We did not belong. And we didn't understand, the practice. And so at one of the meetings, our new executive director attended because they had a lot of questions, and we thought it would be sensible if he be there. We assumed that they would call him in and want to ask him questions, but they didn't want to let him in. He was not a member of the bar of the state of Connecticut yet. He was from Washington, D.C. And he certainly was not a member of the county bar and a member of the association, and therefore, even though he was right outside the door in the courtroom, and it's the housing courtroom that this was taking place in, the third floor courtroom, they would not invite him in. So they had to take a vote, and there was a big debate about whether to invite him in or not, and ultimately by about 2 or 3 votes, it was decided he should be invited in to explain the program. Makes sense. Have the guy come in, at least let him know what the program is about, if they're ever going to discuss it and try and vote on it. So I went out to bring him in, and I said, Fred, these people are crazy. This is really, really violent here. So, be careful. And I thought, how's he going to do this? Now, he had been a professor of evidence down at American University. He got in there, and they started asking questions, and he fielded those questions in a marvelous way, like a professor in a classroom with students. A question was, well, do you have, what can you tell us about the need? Have you documented the need for free legal services for poor people? He said, well, that's a good question. And that's one of the questions we're going to look at. We want to look at that carefully to see exactly what the extent of the need is that we have here. And so every question that was focused at him as an attack, it rolled off. He was able to pick it up and expand and enlarge upon it and make it into really a kind of an academic inquiry. That we were going to look at this and we were going to proceed in a deliberative kind of way. We were going to ask for advice of counsel with respect to claims that are being made that were violating the canons of ethics. We were going to get an opinion. He really diffused that kind of hostility, at least for the moment, at that meeting. They could not reach him. They could not find buttons to press. He was really cool. And I thought when this went on, I thought, we got the right guy for this job because he was able to handle that so nicely. Ultimately, though, at the end of that meeting, the majority voted against New Haven Legal Assistance. They did not want a legal aid program in New Haven. They saw it as being too involved with social work that we were, and not something that was solely a legal program. We were going to do some studying of the need and studying of delivery systems. In fact, we had several different kinds of plans for different kind of delivery of legal services in the community. One was a Judicare kind of plan, that we would have an office where we would refer out pro bono and we would have money to pay. And one was the staff attorney program, that we would have regular staff attorneys who would do the work as opposed to referring cases out. So there were a range of different ideas that we were exploring in connection with delivery of legal services. Ultimately, it was decided that the state bar ought to pass on this, and I think it was the ethics committee that was asked to review what we were doing and to rule on whether we were doing things properly and abiding by the canons of ethics and so forth. They sent us a series of questions, like interrogatories. We had a set of interrogatories that we had to answer. And we prepared answers to those. The committee reviewed that all and ultimately concluded that there was nothing that we were doing that was improper, illegal, or in violation of any of the canons of ethics. And at that point, we proceeded. We held off opening up an office until we got that ruling from the state bar, and then we opened up offices, and we had neighborhood offices on on Congress and on Dixwell. Those were the first two offices. I think it was New Hallville, actually. Those were the first two offices that we opened. We ultimately had maybe 7 or 8 offices going at one point, but that's how we started. In '65, started getting money from the federal government. The Economic Opportunity Act had been passed in 1964. Money was being made available for legal services programs in '65. And we were one of the first programs in the country that got funded through federal funding. This was a very dramatic change from the past. The federal government had never been involved in funding legal services. At this point now, we had Ford Foundation funding. We had some local funding, and one of the things that we did was seek out ways to find funding. We had, at some points, at the very beginning, 10 or 12 different sources of funding. And now the federal government came in and became a major supporter of our program. We're one of the few programs that got funded for our criminal defense work as well as civil, and that's because we always, when we started New Haven Legal Assistance, we always had a criminal defense component, and the Federal Legal Services Program agreed that we would be grandfathered in to continue that. So we've always had a full range of both civil and criminal defense. I'm at a point where I'm beyond the time that I wanted to limit myself to, because I have to go over to a meeting that I have going on right now. So there's far more to this. There's far more to this, but those are the beginning years. That's how it started, it has been on a regular basis a program that, because of what we do, because it's confrontational, adversarial, because of our advocacy, because we are involved in trying to bring about change, that we have, from time to time, difficulties with funding sources, political difficulties with different groups, certainly with the Congress over the years, and certainly with the Legal Services Corporation. And I'm sure Pat will tell you about what our relationship now is with the Legal Services Corporation and with our funding situation vis-a-vis them. But that was the beginning. So.